Okay, hi everyone. I'm really honoured to welcome Alexis Stonebridge from Slater and Gordon to 3003 HSV. She's kindly agreed to speak with us about the role that she plays as a social worker in a legal firm, and I'll let her speak a little bit more to that in a moment. But I think it's really important to think about the role that Alexis has in the context of the work that we've been looking at in relation to the nexus between human service work and the law. Because I think it's the example of social workers working actually within a law firm is a really kind of interesting thing for us to sort of look at in a bit more detail. So with that having been said, Alexis, welcome. And thanks so much for your time. And I suppose, could we start by you telling us a little bit about your role and what you do?
Okay, so I am a social worker employed by a private law firm called Slater and Gordon, which many of you may have heard of before. Slater and Gordon is one of the largest personal injury law firms in Australia and has sort of a national footprint. Slater and Gordon mainly deal in personal injury claims, so that is things like motor accidents, workers' comp, asbestos-related diseases, medical negligence claims, and a few others. And so my role as a social worker is to provide psychosocial support to Slater and Gordon's personal injury clients with any psychosocial issues that may arise during the course of their claim. The service started in 2009 because lawyers at the firm were noticing that their clients were increasingly contacting them with their psychosocial needs. So they may be contacting their lawyer because they're having issues with housing or difficulties with their financial situation, or they're emotionally distressed, or perhaps having suicidal thoughts, and a range of other different things were going on. And the lawyers felt sort of ill-equipped to deal with those issues themselves, but saw social work as being the right profession to come in and to actually provide that support to their clients. And they were the first private law firm to do this. So they were really quite pioneering in saying, you know, we need to more holistically assist our clients with their needs, and recognising that their legal needs was just one small facet of their clients' needs at that time, and just really having a desire to be able to assist them with a wider range of needs within the legal claim context. And so during the course of the claim, if the client presents to their lawyer with any psychosocial issue of concern, the lawyer, with the client's consent, can refer them to us, and we provide them with free assistance, so they're not billed for it at any time, including at the end of their claim. And we mainly focus on providing telephone-based support because we do provide our service across Australia. So it's telephone-based short-term counselling, a lot of referral work and linking people in with existing support services in the community, because quite often our clients have never been in a situation like this. They've sustained a life-changing injury or illness, and they have no idea about where to go to access support. So we refer them to counselling support. It could be support groups, it could be financial assistance or information about Centrelink and other entitlements in the community, just a whole range of things to meet their needs, and some short-term case management until they get linked in with those supports.
Okay. Alexis, I'm wondering, in the course of that work, do you have much to do with your colleagues that are lawyers, or do the two things tend to be run in sort of distinct and sort of separate ways?
Yeah, so we do work quite closely with the lawyers. The lawyers not only refer clients to us, but frequently contact us to consult with us and to get our expertise in managing various different client situations. They particularly consult with us where they may have concerns about a client's mental health presentation, or where the client might be having cognitive difficulties, or they're having difficulty with communicating effectively with the client. It's a range of different circumstances where they may consult with us. And whenever we referred a client by their lawyer and we provide them with assistance, our case notes are provided to that lawyer who then attaches them to their file. And so we're constantly keeping the lawyers updated on the work that we're doing with that client, which not only is helpful for the client, but it's also helpful for the lawyer to understand the broader context of what that particular client has been going through and how that may then affect their participation in the legal claim process.
That's really interesting. I'm wondering whether one of the things that we look at in the course is looking at the preparation of case notes and how to do it in such a way that it's kind of consistent if it was subpoenaed and used in court. And I imagine that a lot of the case notes that the lawyers use may be things that do get used in the process of legal proceedings. I'm wondering, can you speak to that a little bit? Do you have you modified since you joined Slater and Gordon the way you take case notes after sort of in consultation with the lawyers there, or and if so, yeah, what have you learned from that process?
It's quite interesting because within this context, our case notes are dealt with in a very unique way. So because our communication is only directly with the client's lawyer in terms of that documentation, our case notes form lawyer-client privilege, so are not actually able to be subpoenaed in the way that case notes would be in any other context. Having said that, I certainly find it quite interesting in looking at case notes now that I'm coming from this perspective and see how clinical notes are used all the time as part of legal claims process to get an understanding of a client's history, sometimes of the circumstances around how they were injured, in terms of the treatment that they're receiving. And I think what I have noticed is often social workers and other health professionals are on the side of not providing a lot of detail, which is actually quite problematic for the client because it doesn't provide a true reflection of the service that they've then accessed from that health professional. And it often doesn't cover all of the things that have actually been involved in that. And so what I think I've learned, and I think I reflect now on the 10 years in my previous job before coming to this one, I was always pretty comprehensive with my notes, but I think now on reflection, I have a better understanding of how it is important to be quite comprehensive with notes, to make them contemporaneously, so not have delay in between when you're seeing a client and when you're writing the notes, to make sure they're justifiable so that, I guess having an understanding of how they might be used in the future is helpful, because whilst they might not be, they very well may be used in a court situation. Other people will have access to the notes, and we can't assume that those people that see the notes later will understand what we meant by certain notations we might make. So making sure that we're comfortable that the notes adequately represent our service to that client and they would be understood by someone who's not a social worker and who's in a very different context.
That's really, really interesting. I am wondering about, I suppose, one of the key themes that we're kind of working through in this initial part of our course is thinking about that nexus between the law on one hand and human service or social work on the other, and the importance of kind of having a relationship that sort of cuts both ways on that. And you're in a really unique position, I suppose, to talk about that because you are very much connected with the legal profession in a really direct sense. So I wonder if you could speak to that, about either what you've learned or what you think the lawyers at Slater and Gordon have learned from working with human service workers, with social workers, and vice versa, what you've taken away from that relationship, and maybe even what you think the key to success in that type of relationship is.
Yeah, I think one of the major things that I've learned since being in this role for 10 years is how lawyers and social workers have such similar goals. And I think where there have been tensions perhaps between the two in the past, it's been about a misunderstanding about the role of each of those and how similar our goals are. I mean, I'm talking from a plaintiff perspective, so this is a firm that represents individuals in the same way that social workers do. And I think those common goals place us really well in terms of working together. Actually, the CEO of our firm recently gave a speech, and I just copied a quote from that I'd like to share because I think it talks to this point. He said, the role of plaintiff law firms in assisting injured people is in addressing the growing imbalance between owners of capital and owners of labour. That is the imbalance in power between big corporations and everyday people. We see this imbalance playing out more and more with large corporations such as energy companies, banks, telcos, and of course, insurers. The poor individual's ability to seek redress is significantly challenged. In the case of a person severely injured, often they don't have the understanding, the capacity, or the power to challenge organisations like insurers, and therefore are just subject to decisions made about them that may not be in their best interests. Plaintiff law firms, particularly ones that offer pro bono or no win, no fee representation, step into that power difference and create balance. They provide empowerment to the individual to seek choice, agency, and the ability to advocate for their needs to be properly met. And I think what struck me about that is exactly the goal of social workers as well. Our goal is really about advocacy and about evening up that power imbalance, about people's access to have their voice heard and their needs met. And so I think what I have learned is that we have those common goals and that we can actually be utilising the lawyers and the law in order to better have our clients' needs met. And I think what we could learn really is what people's options are so that we can then present these options to them. So I certainly don't believe that social workers need to become quasi-lawyers and know everything about law, but by knowing a little bit about law, it actually is helpful for us to know the right questions to ask of our legal colleagues when a person might have entitlements. So for example, a client might need assistance with their rights with Centrelink with respect to social security legislation. They may have been denied a payment when they shouldn't have, and a little bit of understanding about social security legislation can help us to know actually we need to advocate for this person to have to make an appeal or to get additional advice. Or they may need advice with anti-discrimination law or immigration law or criminal law. They may need a will or to appoint a guardian. There's a whole range of different legal issues that may arise during the course of your work with a patient or a client. And having that little bit of knowledge and knowing where to go to get more information equips you to empower a client to actually address the situation and have their voice heard and their needs met.
Oh, thank you. I think that's really well said.